Let me welcome you to the first event of the 112th ACIL annual meeting and the 20th anniversary of this Grotius lecture. We do this lecture in partnership with American University's Washington College of Law, and it's been a strong and fruitful partnership over the years, and we're delighted to be able to do it. Let me also welcome our distinguished guests, Judge Joan Donohue and Professor Dapo Akande, and in a moment I will introduce Professor Padideh Alive from American University, Washington College of Law. Where is Padideh? There she is. Okay. Please come to the podium, Padideh. Padideh is someone I've known for a long time. She's just reminded me that we were in an upstairs, downstairs situation some years ago when she was a practicing lawyer and not a professor, but currently she is a professor of law at American University's Washington College of Law, and she's also the director of the college's International Legal Studies and Hubert Humphrey Fellowship programs. And in that role, she represents, promotes, and coordinates the innovative and highly recognized international programs of the law school. She received her JD from Harvard Law School, and prior to joining the Washington College of Law, as I mentioned, she was in private practice, representing governments from developing countries, as well as foreign companies doing business in the United States. The subjects she teaches include international trade law, comparative law, and her scholarship has addressed a wide range of issues, including the history of free trade, transparency obligations of the WTO, and the multilateral trading system, as well as issues of good governance and the evolution of international anti-corruption norms. And some of our mutual interests have brought us together over the years. So it's my distinct pleasure to welcome Padideh, and she will introduce our Grotius lecturer and discussant. Thank you.
Thank you, sir. Thank you, everyone. I want to thank Lucinda, Mark, Wes, and everybody at the American Society of International Law. It's been a real partnership and a pleasure to work with them. I'm going to do a little housekeeping. I'm going to request that you make sure that your phones are either off or on buzzer, because inevitably somebody's phone is going to go off at some point. So on behalf of American University Washington College of Law, I welcome you to the 20th Annual Grotius Lecture. This year marks the 2 decades of collaboration between American University Washington College of Law and American Society of International Law, and we look forward to the next 20 years and beyond. This year, I would also like to thank the law firm of Akin Gum, my good friend Hal Shapiro and Matt Hawkins, who will co-sponsor the reception, the Grotius reception that will follow this lecture. The original motivation for this lecture was to create a forum to address broad themes and issues. The lecturer would be asked to speak on a topic related to the theme of the ACIL annual meeting, but from a perspective that may be unlikely to be represented in the individual sessions of the annual meeting. The idea of having a discussant was to ideally have someone from a different perspective and background experience and approach than the lecturer, and someone who would expand on some of the issues raised in the lecture. The hope has always been that the combination of the two would provide the audience with food for thought and stimulate new ways of thinking about the topics to be discussed during the annual meeting. Grotius, I'm told, came as an obvious title because of who Grotius was as the father of international law, at least in the West, and perhaps also because at the time, our dean, Claudio Grossman, and the director of the International Legal Studies program, Daniel Bradlow, who are both here today, I believe, also spoke Dutch. Claudio had been a political refugee from Chile who was forced to leave his country to seek asylum in the Netherlands, and Danny had left his native South Africa also in opposition to the apartheid regime. For them, for us, a Grotius moment with emphasis on role of international law, that the role international law can play in shaping and projecting a future was personal. I'm honored to follow in their footsteps, and perhaps it is not a coincidence that I also had to leave my native country of Iran fleeing religious persecution. As we celebrate the 20 years of Grotius lecture, I want to remind everyone of the vision that animated those of us who have sought refuge in the values of international law and in the institutions of higher education here in the United States. Over the last 2 decades, the Grotius lecturers and commentators have included Nobel Prize winners, political leaders, senior officials of international organizations, International Court of Justice judges, historians, philosophers, and lawyers from around the world. Today, we are indeed very privileged to have Judge Joan Donohue of the International Court of Justice with us as our 20th Grotius lecturer. Judge Donohue has served on the ICJ since 2010. Prior to her election to the ICJ, Judge Donohue had a long career in the US government, serving from 2007 to 2010 as the principal deputy legal advisor for the US Department of State. In addition to her government service, Judge Donohue has taught courses at University of California, Berkeley, Georgetown, and GW University. Our commentator today will be Professor Dapo Akande, who is Professor of Public International Law at the University of Oxford and co-director of the Oxford Institute for Ethics, Law, and Armed Conflict. He has held visiting professorships in Yale Law School, University of Miami Law School, University of Vienna, Católica Global Law School, Lisbon, Portugal, University of Melbourne. Professor Akande is also a member of the International Advisory Panel for the American Law Institute's project on Restatement 4th, Foreign Relations Law of the United States. He's a trustee on the board of the British Institute of International Comparative Law and a counselor of the American Society of International Law. So Judge Donohue will start us with her lecture, and immediately following will be Dapo with the commentary. And then afterwards, I will take questions from the audience. Judge Donohue.
Last time that I stood before lights this bright was in the Hague Academy during the asbestos crisis, when we judges were expelled from the Great Hall, and we had to hold a hearing under lights, and it was similarly difficult to see. So I apologize if I struggle a bit. Thank you, Lucinda, Padita, wherever you are, for those kind remarks, and thank you also to the Washington College of Law at American University for its sponsorship of this important lecture series over the years, and to the Society for inviting me today. Thank you also to Professor Akande for agreeing to serve as discussant. This lecture is not styled as a tribute to David Caron, but as I said to Lucy Reed walking in, David always sat in the front, and I have Kleenex because, contrary to what Chris Greenwood told me at lunch today, he said, "Oh, don't worry, you won't lose it when you mention David." I didn't trust myself. It's not a tribute, but you will hear me mention David's scholarship, which was important to me, as were my discussions with him over the years, and especially since he joined me in The Hague. I'm going to talk today about international dispute settlement mechanisms in which at least one of the parties is a state, and focusing on 2 of those mechanisms. One, the International Court of Justice, and the second, much more briefly, investor-state dispute settlement. I have a few limitations on the scope of this lecture to mention at the outset. First, of course, the role of the International Court of Justice is broader than the settlement of disputes between states due to our due to our advisory opinion jurisdiction. And second, I recognize that it's difficult and to a considerable extent artificial to speak of the performance of any dispute settlement mechanism without addressing the substantive outputs, but I don't attempt today to address the substantive decisions of the International Court of Justice or those that come from investor-state tribunals. I also wanted to mention that when I speak in front of an American society audience, I'm mindful that many of you are academics, and that the process of adjudication has been the subject of extensive academic commentary. So when I stand here, I think, well, let's see. Some of you say, I'm an agent of the states. And some of you say, no, 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 you're not an agent, you're a trustee. And then even others say that I'm being pulled into the 3 corners of the so-called judicial trilemma. And I'm also aware that it can be difficult to disentangle your empirical assertions from the normative contentions that you make. So these assertions that are made by academics are not made in a laboratory subject to pristine, double-blind conditions. So as I said to Professor Akande earlier today, you may look at me and say, oh, there's a speaker standing in front of a room. But when I think of myself standing in front of a group like this with many academics, I imagine myself lying on a laboratory table with electrodes attached to my arms and legs, and with each professor taking readings and seeking to assess them against his or her hypotheses. So with that laboratory imagery, let me shift from that image to the outdoor imagery suggested by my lecture title, The Peaks, Valleys, and Rolling Hills of International Dispute Settlement. What I have in mind is that when explorers start out on a new adventure, the public attention is captured by the stunning photos of the peaks that they seek to scale. And at times, our focus shifts also to calamities, disasters. Maybe the explorers are trapped in a valley. Perhaps they'll abandon their quest. What does not attract media attention, on the other hand, is the days of trudging up and down through the rolling hills with a mix of progress and setbacks, rechecking the map and adjusting the route. But it's the choices that individuals make outside of the media spotlight that can determine ultimately whether the voyage is successful or not. And I see similar patterns in the way that our profession approaches the international settlement of disputes. When new mechanisms for dispute settlement are proposed, the proponents are driven by the belief that existing mechanisms don't work, they're insufficient. And the objectives of proponents are often, like peaks to be scaled, very ambitious, very lofty. But once a mechanism for international dispute settlement is established and begins to operate, shortcomings start to emerge. And criticisms are voiced by some who are frustrated that those animating expectations have not been fully realized, and by others who are actually hostile to the particular mechanism and wish to destabilize it. We've seen these patterns, for example, in respect of the International Criminal Court and the WTO. These actual and asserted shortcomings of an international court or tribunal can be like deep valleys. But most of us who work in the field of dispute settlement, I think, can see ourselves day in and day out in the rolling hills, translating into the vocabulary of this annual meeting in the practice of international dispute settlement. So today I want to spend some time talking about the aspirations for a world court, the shortcomings that have emerged, and the challenges and opportunities for those of us who work inside of the rolling hills. And then I'll make some briefer comments involving investor-state dispute settlement. With respect to the aspirations for a world court, we have to start at the Hague Conferences in 1899 and 1907. And most ambitiously, the goals of the proponents of a world court there were very bold, that states would adjudicate instead of going to war. The occasional resort to ad hoc arbitration was not seen as an adequate means of getting disputes into a courtroom. More concretely, those proponents sought to establish a world court with what seemed to me to be 6 important characteristics. They wanted a standing court. They wanted a court with authority to settle the full range of disputes on all topics subject to international law. They wanted the decisions of the court to be binding on the parties. And they wanted a court from which jurisprudence would emerge as distinct from arbitration. And to that end, its decisions would be public. They also wanted a court with independent and authoritative adjudicators, and a court that would attract widespread adherence by states, a court that would have jurisdiction over all states and that states would use routinely. Well, as we know, the Hague Conferences did not produce a world court. Aspirations continued, eventually leading to the statute of the Permanent Court of International Justice, and later the statute of the International Court of Justice. So how does the ICJ statute measure up against the 6 Hague Conference aspirations that I listed? It fulfills 4 of them. It's a standing court. Its proceedings and decisions are open to the public, and thus there is a prospect of creating a jurisprudence that is potentially influential on non-parties to a case. The judgments are binding on the parties to the dispute, and the court has scope to settle disputes between states without excluding any particular topics as being, for example, too sensitive for international adjudication. What about the objective of an authoritative independent bench? Well, the ICJ statute attempts to mediate among what were competing visions of an ideal bench that had been obstacles to the success of the Hague conferences. And briefly, the process works like this. Within each state, a group of up to 4 persons with competence in international law, the so-called Permanent Court of Arbitration National Group, nominates candidates for the court. And those candidates should meet substantive criteria. They should either be qualified for appointment to the highest court of their respective states, or they should have recognized competence in international law. So the statute puts the nomination of candidates in the hands of people who are supposed to be experts in international law and who are supposed to have, by design, some distance from governments. However, it's states that ultimately elect the judges, and they do so by simultaneous secret ballot in the UN Security Council and in the General Assembly. Importantly, the statute does not speak only of the individual qualifications of candidates. It also calls for a bench that has a representative geopolitical distribution. In practice, over many decades, this has led to traditional allocations of seats among UN regions. And at least until the 2017 election, it also has involved a tradition that the court would include a judge who is a national of each of the P5 states. The last point that the court sets out in respect to the election of judges is that judges, once elected, are to be independent of states. I'll say more about the way this process of judicial selection has functioned, but that's an overview of how the statute operates. The 6th characteristic that was sought by World Court proponents in the Hague conferences was not achieved by the ICJ statute. The proponents sought a court that would have jurisdiction over all states. However, UN member states are not required to accept the court's jurisdiction, nor are they required to submit disputes to the court. The statute does not leave states with a binary yes or no choice on the court. They can accept the court's jurisdiction generally, they can do so with reservations, they can accept it only for particular treaties, they can accept the jurisdiction only with respect to known disputes, and they can change their consent to jurisdiction over time. So what that means is, under the statute, the fulfillment of the initial aspiration that states would be subject to the court's jurisdiction and would bring cases to it depends on decisions to be taken by states. And that means that we need to look at how that has worked in practice, which brings me to a valley in relation to the World Court. When we ask ourselves the question, to what extent have states demonstrated their trust in the court, both by consenting to its jurisdiction and by bringing cases to it? Well, in comparison to what must have been the aspirations of the proponents of the World Court at the Hague conferences, in the negotiation of the PCA and ICJ statutes, the situation has to be disappointing. The number of declarations is lower than they would have liked to see, well under half of UN member states. Very few cases have been brought in certain periods. There has been hesitancy about the court, especially among powerful states. And states have sometimes reacted to losses in the court by distancing themselves from the court. They've also at times declined to appear as respondents or withdrawn from proceedings, although fortunately not recently in the case of the ICJ. Those who are critical of international adjudication, and especially of the World Court, depict this situation as a very deep valley indeed, and they also deride the kinds of cases before the ICJ as, for example, small-scale conflicts or cases presenting only technical issues. So in my imaginary band of explorers, these sorts of critics would be the ones saying, see, we told you it would never be possible to scale this peak. But of course, The situation of the ICJ does not need to be described as bleakly as those naysayers might have it. Even those of us who support the idea of a world court, however, and want it to succeed, can and should acknowledge and look seriously at shortcomings. And I want to mention two shortcomings today that may have an impact on the ability of the ICJ to meet the aspirations of the world court, the process of judicial selection, and the working methods of the court. I described the formalities of the process earlier. Now, I want to look at it a little bit more closely, and this has been the study of the subject of considerable study and analysis. Within many states, the process of national group nomination has not worked as had been hoped. National groups in many places rarely have serious processes for vetting the qualifications of candidates, and the number of candidates nominated in each election is usually very small. The election process in New York is attentive to geopolitical representation, as it should be. However, my own impression, having campaigned in New York and having observed elections for the ICJ, is that the nationality of candidates overtakes all other considerations. Vote trading dominates the process for many states. In meeting after meeting that I had as a candidate for the ICJ, I wondered whether my individual qualifications would have any impact on the question whether that particular state would vote for or against me. This process of judicial selection would disappoint those proponents of a world court who hoped, I think unrealistically, that nomination by national groups would reduce the political nature of judicial selection. At the same time, the focus in New York on the nationality of candidates offers fuel to some of the court's harshest critics, who claim that nationality is the key determinant in the way that we as judges vote. Now, if the process of nominating and electing judges is flawed, this can affect the willingness of states to embrace the court. And here I quote from David Caron, who said in his 2000 American Journal of International Law article on the Hague Conferences, "The quality of judges as individuals and the process by which they collectively reach a judgment resides at the core of both the respect accorded to the court and the willingness of states to consent to its jurisdiction." Now, David's one sentence speaks both of the quality of the judges and the process by which we make our decisions. And that leads me to our working methods. Our working methods are often criticized for being too slow, too passive, and not amenable to change and to adaptation. So I've described here, and perhaps to a certain extent exaggerated, a valley characterized by disappointing state embrace of the International Court of Justice. And I've suggested two of the factors that could contribute to that disappointing state embrace: our working methods and the process of judicial selection. I want to emphasize that I recognize that these are not the only factors that may contribute to states' hesitancy, and that there are, in fact, some very fundamental reasons that may be as important or more important for certain states. But now I'd like to turn away from this gloomy picture and move on to the rolling hills of practice, which is the terrain that I inhabit as a judge of the ICJ, and surely the place where quite a few of you spend your days as adjudicators, as staff of various organizations, as advocates, as academics, and in other roles. So I start by noting that the track record for interstate dispute settlement since the Hague Conferences can be cast in a far more favorable light than I have suggested so far. Both the Permanent Court and the International Court of Justice have decided cases that have been important both to the parties and to the world community generally. There have been indisputable luminaries on both courts. And in recent years, fortunately for me, the ICJ has been very busy, and the cases have been diverse, interesting, and important. The broader environment of state-to-state dispute settlement can also be seen in a positive light. States now have multiple options for settling their disputes in a courtroom. Intrepid individuals within the Permanent Court of Arbitration have, over a period of decades, entirely reinvented and reinvigorated that organization. And new international courts and tribunals abound. This so-called proliferation, which has been written about at times as a negative development, I think is really very positive, even if it stems in part from certain misgivings about the idea of a single world court. It allows us to recalibrate our expectations for dispute settlement beyond a single world court. We can aspire to make the international courts and tribunals, both individually and collectively, attractive as places to settle disputes in healthy competition with each other. This aspiration for all the international courts and tribunals should drive us forward, but it also has to be tempered by the recognition that a state's decision to place its interests in the hands of an international court is a weighty one. As compared to the days of the Hague conferences, we can be pleased that there is more adjudication and arbitration today, but we should not be surprised if it remains the case that most settlement of interstate disputes takes place outside of adjudication and arbitration. Well, in addition to broadening our aspirations from one single world court to a group of thriving international courts and tribunals, we must also re-examine our particular aspirations about the International Court of Justice. The drafters of the UN Charter, the mandate providers, to use the terms of Professor Yuval Shany, assigned to the court the functions of deciding contentious cases and rendering advisory opinions. They created a body that was accountable not only to the parties, but also to the entire world community. They envisioned that in the course of the functions assigned to it, the court would develop a publicly available jurisprudence, inevitably developing international law and thus having an impact beyond the parties to the state. However, because the jurisdiction of the court under the ICJ statute is not compulsory, the ICJ's ability to fulfill these goals through deciding contentious cases depends on the extent to which there are cases on the court's docket. Thus, to advance the core aspirations for the World Court, we must keep our focus on the attractiveness of the court as a place for states to settle disputes. And there are two sides to that coin. States must not only see the court as a forum in which they are prepared to initiate cases, but also as a forum in which they are prepared to be named as respondents. So, how can those of us in the practice of dispute settlement in the rolling hills work towards those objectives? I'm going to make 4 suggestions. First, we need to work within the confines of the statute of the International Court of Justice. The statute cannot be amended except by the same process that applies to amendment of the UN Charter, and there's no reason to expect an amendment of that sort anytime soon. Second, we must not overload the International Court of Justice with expectations for which it was not designed. Commentary on ICJ judges, especially from academics, frequently reveals a hunger for more lawmaking by the court. The appetite for more development of law by the court is understandable. There is no robust legislative apparatus at the international level. However, such an approach by the court poses risk. Once again, David Caron. David used vivid imagery a year ago in the Brower lecture here in this building, saying that international courts are screwdrivers that are being asked not only to place screws, but also to hammer nails. David observed that if courts are used excessively as hammers, they will cease to function as screwdrivers. The ICJ does have scope to develop international law, but it should do so only in the course of performing its assigned functions of settling disputes and issuing advisory opinions. By operating within those limits, the court can contribute to the confidence of states, putting it in a position to fulfill the aspirations that drove the idea of a world court. My third suggestion is a suggestion for my own court. We must be more energetic in improving our own working methods, drawing from and adapting procedures that have been successful in other settings. In 2006 and again in 2016, the court held conferences at which adjudicators from other courts, counsel, professors, and various others joined us to talk about ways to improve the court's working methods. And after both conferences, volumes were produced summarizing the outcomes. However, the last amendments of the court's rule were modest and were in 2005. And outside of these formal rules of the court, there have not been very many changes in the way the court operates. There is on the International Court of Justice a rules committee. 7 judges serve on that committee at any time, and I sit on that committee. And that is the forum in which ideas for a procedural improvement can be developed for consideration by the full court. The current chairman of the rules committee is former President Peter Tomka, and he and several other members, I include myself, are quite keen to make progress. Under the guidance of President Youssef and Vice President Shui, I'm hopeful that we'll be able to act on some of the ideas that were presented at these earlier conferences. My final suggestion for what we can do in the Rolling Hills is directed at various of you in this room. And this relates to the process of nominating and electing judges of the ICJ. I speak in the awareness of the fact that about half the members of the American Society are not from the United States, such that I know I'm addressing an international audience. There can be no doubt that geopolitical balance is important, both to the legitimacy of the court's decisions and to its internal operations. There will continue to be debates about exactly how to strike the right balance, but balance there must be. However, surely international lawyers around the world can take a more active role in re-energizing national group vetting and nominating processes. There have been some ideas suggested in particular studies. My own impression is this is very much retail work, that there's no one-size-fits-all solution, but improvements do need to be made. Turning to the process in New York, I don't expect people in this room to eliminate vote trading. However, my impression is that there is a near-exclusive emphasis on nationality during the election process in New York. This creates a false impression as to the importance of nationality in the operation of the court. We judges doing our jobs in the court, we are not 15 flags stuck into the necks of robes. The collective capacity of the court to fulfill the responsibilities given to it in the UN Charter depends on the combined individual qualities of each judge. And these include expertise on international law and on dispute settlement, an appetite to wade through evidence, and energy and rigor that is needed to draft the court's judgments, which we do as a collaborative group process. The busier the court is, the more important it is that each judge has these important qualities. It falls to international lawyers like those of you in the room to engage seriously with candidates, to make known your assessments of their capabilities, to share those assessments with the representatives of member states who will be voting, and to stress to those representatives the importance of and the way that the output of the court depends on the individual qualities of those who sit on the court. Now, these are not the only ways that those of us in this room can contribute to the improvement of the International Court of Justice. I can certainly think of quite a few others, and I'm sure you can as well. But the key point for me is that we need to look at the aspirations, recalibrate them as we see appropriate, and accept that improvements can and should be made and figure out how to make them. Let me turn briefly now to a comment on the peaks, valleys, and rolling hills associated with investor-state dispute settlement. Before investor-state arbitration came into existence, the mechanisms for addressing investor-state disputes were reliance on local courts or diplomatic protection by the investor's state of nationality. These mechanisms can leave the investors without any adequate remedies, and they can lead, and have led, to state-to-state conflict, at times including so-called gunboat diplomacy. By creating the ICJ Convention, and thus a mechanism for direct settlement of investor-state disputes in a neutral forum, the World Bank sought to overcome these difficulties and thus to increase capital flows to developing states. But just as the ICJ statute does not require UN member states to accept the court's jurisdiction, the ICSID Convention leaves state parties and investors free to use investor-state arbitration or not. The mechanisms, therefore, can only meet aspirations if states embrace it, which they've done in 3,000 or so treaties, and if investors use it, which they've done in hundreds of cases filed so far. So we don't have a problem with use, as we have had at times in the ICJ. At present, however, it could be said that investor-state dispute settlement is in a valley of doubt. The most fundamental attack on investor-state arbitration as part of a broader invocation of a notion that's labeled sovereignty, which is used to condemn not only international courts and tribunals, but also substantive provisions of treaties, including but not limited to investment treaties. For those who hold these views, it would appear that the path out of the valley of doubt is simply to reverse course and head back to base camp. Those of us who remain convinced of the need for an international mechanism for settling investor-state disputes find ourselves instead in the rolling hills. And my impression is that the field of investment law has constantly proven itself to be adaptable. Recent examples include the evolution of ideas on transparency and confidentiality and the ongoing rules amendment project underway at ICSID. Of course, there are also proposals to replace investor-state arbitration with an investment court. Now, I'm not going to debate here the pros and cons of these proposals. There's an opportunity to do that later in this conference. But my observations about the ICJ lead me to two particular cautions about a possible investment court. First, if adjudicators are to be elected by states, there is, I think, a significant risk that the process will be taken over by political considerations, such as the rotation of seats among states, with inadequate attention to the qualifications of individual candidates. And second, just as the ICJ can only meet aspirations if states embrace it, both as potential applicants and as respondents, so too any mechanism for the settlement of investor-state disputes must meet both the interests of states as respondents and investors as claimants. If that's not the case, disputes will not be brought to the mechanism, and we can find ourselves back in the days of gunboat diplomacy. Well, stepping back from this overview of the World Court and these briefer comments on investor-state dispute settlement, I go back to the time when each of them was created. And when I think about the quest for a World Court in the Hague Conferences in 1899, 1907, and the proposal within the World Bank to create this new international mechanism for settling investor-state disputes, I appreciate these were both big and bold ideas, and they remain bold today. Third-party dispute settlement asks a great deal of states. They are expected to place their trust in international adjudicators and international institutions whose decisions are binding on them. They are expected to maintain that trust even when, as is inevitable, they don't always like the decisions that come out of those courts and tribunals, and even when they lose cases. Today, more than ever, and it seems increasingly with each passing day, powerful voices launch strident attacks on international agreements and international institutions, including those involved in the peaceful settlement of disputes. Those of us engaged in the practice of international law must fight back both by countering their exaggerated criticisms and by being open-minded about and candid with ourselves about the need to improve dispute settlement mechanisms and the institutions associated with them. There are days, to be sure, when each of us feels that we're at the bottom of a valley in which lofty aspirations seem unattainable. However, we should not abandon the pursuit of peaceful settlement of disputes. Instead, we should pull out our compasses, make some course adjustments, and continue to work our way forward through the rolling hills. Thank you to all of you, and I'll turn the floor over to Donohue.
It's a pleasure as well as an honor to be asked to respond to Judge Donohue's Grotius lecture. I wish to extend my thanks to the American Society of International Law and to the Washington College of Law, American University, particularly Professor Padide Alive, for organizing this lecture. It's a daunting task to follow such a brilliant lecture full of insight, and one which draws on years of practice in several capacities, as well as on significant reflection. Judge Donohue has provided us with a tour of the ideas that have inspired, but also which have limited the prospects that states might settle their disputes through adjudication and on the basis of international law. In the time that I have, all that I can do is to try to explore a few of the ideas and thoughts in a bit more detail. Before I begin, let me also pay my own tributes to Professor David Caron, the recent president of the American Society of International Law, who most unfortunately passed away recently. His academic and practical contributions to the field are immense. For those of us on the other side of the pond, we saw firsthand over the last few years his leadership skills as Dean at King's College School of Law in London, where he rejuvenated the study of international law and transnational law, and indeed the law school as a whole. Using the powerful metaphors that Judge Donohue used, she invites us to think about the peaks, the valleys, and the rolling hills of international adjudication, concentrating in particular on the International Court of Justice and on investor-state dispute settlement. Before engaging with Judge Donohue's ideas regarding the ICJ and investor-state dispute settlement in particular, we may wish to consider where we are today with regard to international adjudication more broadly. Depending on how one defines them, standing courts as mechanisms for international adjudication of questions of international law are barely a century old. Reference was made in the 1918 Covenant of the League of Nations to a permanent court of international justice that was established a few years later. However, that court was more or less alone as a standing court for adjudication of interstate disputes, as the Central American Court of Justice, which was created in 1907, had already ceased to function by the time the PCIJ held its first hearings in 1922. When the International Court of Justice was established in 1945 by the Charter of the United Nations, it was referred to in the Charter as the principal judicial organ of the United Nations. It was, however, the only judicial organ created by the Charter, and there was no international judicial system to speak of. But today, as Judge Donohue has pointed out, the situation is strikingly different. We now have a large number of international tribunals that are charged by states with resolution of disputes or other legal issues on the basis of international law. And that range is impressive, from tribunals dealing with interstate adjudication to those dealing with international criminal prosecutions to mixed disputes between states and private entities, whether of the human rights variety or of the investor-state variety. And in addition to this increase in the number of tribunals, it is useful to remember in addition to this increase in the number of tribunals, there is also a significant increase in the number of cases before practically all of these tribunals. It's useful to remember that in a century, we have come a very long way. Indeed, it is over the last quarter of a century that the change has been most impressive. And in some senses, I feel sorry for students of today. I recall that when I studied for my LLM in international law 25 years ago, it was possible to say that one had read the judgment delivered by every international tribunal in that year, as long as one excluded the judgments of the European Court of Human Rights. The ICJ in that year delivered one merits judgment, The international criminal tribunals for the former Yugoslavia and for Rwanda had barely got going. The International Criminal Court was still some years off, and the World Trade Organization agreement was just being concluded, and its dispute settlement system was not yet operational. There had been some investor-state arbitrations, but the explosion had not yet occurred. And how easy it was to study international law in that world with relatively few international tribunals. Now, I remind us of these developments because it may be argued that we are at one of those peak moments that Judge Donohue describes with regard to international adjudication. The aspirations that international disputes will be settled regularly on the basis of law and before international tribunals is more of a reality today than at any time in history. However, from peaks, one can see the valleys below, both those that are behind us and those that are ahead of us. One can also hopefully see the paths that lead to those valleys, and with good fortune, how to avoid them. From the current peak position, we see that in many respects, the picture that I have just painted of an increase in the number of courts and tribunals, and also of cases before those tribunals, is slowly fading and being ripped apart. And this is happening across the range of international adjudication. Judge Donohue spoke about the valleys in ICSID, the moves to curb investor-state dispute settlement more broadly, withdrawal by some states, and we see similar trends elsewhere with withdrawals from the statute of the International Criminal Court and the systematic, perhaps one might even say systemic, disruption of dispute settlement in the World Trade Organization by the refusal of the US to allow for new appointments to the appellate body. Within the UK, there was talk of withdrawing from the European Convention of Human Rights and therefore from the Court of Human Rights, a development that seems only to have been shelved by Brexit and withdrawal from the European Union. All of these threats to international adjudication mean that despite the fact that we are very far off from where we were a century ago at the creation of international adjudication, as we now know it, there is a need, as Judge Donohue spoke about, to redouble our efforts to once again articulate the benefits and the goals of international adjudication. However, we need to be careful as to what those aspirations are and how they are to be achieved. Judge Donohue set out for us the 6 characteristics that were sought for a world court at the Hague Peace Conference and what was actually achieved in establishing the PCIJ and later the ICJ. Let me start with one of those 6 characteristics, which I think we now pay little attention to, but which was rather significant a century ago, and where attainment of that aspiration has taken time. This is the idea of a court that has scope to settle legal disputes between states with no subjects being excluded as being too sensitive. It's one of the 6 that she mentioned. This was not a proposition that was to be taken for granted a century ago. From the time of Vattel to at least the early part of the 20th century, the prevailing view among both international lawyers and statesmen was that there were certain inherent limitations in the judicial function, and that obligatory judicial settlement of some, if not most disputes between states was inappropriate. This doctrine of the inherent limitations of the judicial function in international law classified disputes into those that were justiciable and those that were non-justiciable, disputes as to rights as opposed to disputes arising out of conflicts of interest, and legal in contradistinction to political disputes, all these terms being different ways of saying the same thing. The alleged dichotomy between legal and political disputes was the defining intellectual framework in the conception of the international judicial function. Moreover, it was often thought that the test for determining which disputes were legal and which were political was the importance of the subject matter of the disputes. Hirsch Lauterpacht, writing in 1943 in his The Function of Law in the International Community, stated that, and I quote, "According to this test, Those disputes are political and therefore non-justiciable, which affect the important, or to use the current expression, the vital interests of states, end quote. The contention that the court, the PCIJ and later the ICJ, was not competent to deal either with a contentious case or with an advisory opinion on the basis that it involved a political and not a legal dispute was one that the court faced in a number of cases. However, the court made clear that the fact that a dispute has political aspects or that its decision will have political implications does not debar it from exercising its jurisdiction once it is properly seized of the case. The court patiently explained in a series of cases that what is important is whether the particular questions before the court can be settled or answered by reference to international law, and if they can, the court is competent to answer those questions regardless of the political circumstances surrounding the case. Over time, the artificial nature of this alleged distinction between legal and political disputes has come, I think, to be accepted by states with regard to the ICJ. This type of objection to the court's competence is no longer heard, I think, in the Great Hall at the Peace Palace, at least not heard in this direct way. However, the contention that some disputes are incapable of being settled by tribunals on the basis of international law is once again rearing its head in other parts of the landscape of international judicial adjudication. In particular, it has been argued by states that where they take measures in order to secure their national security interests, this will mean that the disputes regarding those measures are non-justiciable in the dispute settlement system of the World Trade Organization. These arguments have been made in a series of recent cases by Russia, but also in the context of a dispute involving the embargo of Qatar by other Arab states. Similar arguments have also been made and rejected, dare I say, in investor-state dispute settlement. Just like the ICJ did with respect to the legal-political dichotomy, WTO panels and the appellate body will need to engage in careful legal analysis, setting out what is legally justiciable and what might not be. It seems to me that some of the text of the relevant legal instrument, Article 21 of the GATT, sets out conditions under which that national security clause can be invoked. It does not exclude examination of entire disputes from the purview of the dispute settlement system once it is invoked, but does leave some room for a degree of deference to states who nonetheless have to make a good faith determination of their essential security interests. Let me now turn to the rolling hills that Judge Donohue mentions with respect to the ICJ. She said that we must keep our focus, I'm quoting now, we must keep our focus on the attractiveness of the court as a place for states to settle disputes. As she also noted, the docket of the court is full at the moment. There are cases involving states from every continent. However, again, from these peaks, we can see down into those hills and observe the places where dips might be coming. Judge Donohue has mentioned that optional clause acceptances are relatively low. In fact, most cases come to the court not on the basis of the optional clause, but on the basis of compromissory clauses in treaties. The current cases that have come to the court have come because of previous treaties that included resort to the court as a basis for dispute settlement. However, it should be noted that there has been an appreciable decline in the number of treaties which include compromissory clauses providing for recourse to the ICJ as a method of dispute settlement. If you look at the court's website, it seems that there has been no such treaty providing for reference to the ICJ in a compromissory clause since 2006, so that's 12 years. This is a worrisome trend, especially when it is combined with the fact that in practically every year between 1945 and 2006, there was at least one treaty concluded between states, including a compromissory clause that referred to the court. In addition to this decline in the number of compromissory clauses that refer to the court, the form of the typical compromissory clause included in relatively recent multilateral treaties has changed. Previously, such clauses typically provided for reference to the court as the sole method of compulsory adjudication of disputes. However, the clauses in more recent multilateral treaties, those which do provide reference of disputes to the court, rarely, if ever, provide for the court to be the sole or even the primary method of dispute settlement. How then might the attractiveness of the court as a forum for interstate dispute settlement be preserved in an age in which the ICJ is but one means available to states? When one examines the factors that may lead parties to choose the court as opposed to arbitration, it will be readily seen that the court has differing degrees of control over these factors. However, with respect to the issues where the court does have control, it is worth examining what might be done to encourage submission of cases to the court. Judge Donohue spoke about possible rule changes in this regard. And the experience of the court itself shows that changes instituted by the court with respect to its rules and procedures can affect the attitude of states considering adjudication of disputes. It is well known that amendments to the rules of the court in 1972 and 78, which provided that the president of the court shall ascertain the views of the parties regarding the composition of ad hoc chambers, signaled to states that the court would be disposed to the formation of chambers composed of those judges that the parties particularly desired for in the constitution of the chamber. And following that revision, or those revisions, 4 requests for submission of disputes to ad hoc chambers were made in the 1980s. Now, though those revisions have been the subject of some criticism, it cannot be denied that at least for a time, they encouraged some states to look at the court with fresh eyes. However, it's interesting to observe that the tendency to refer matters to ad hoc chambers, which had not been done before the revisions in the 1970s, now appear to have receded. Only 2 further references to chambers were made after those cases of the 1980s, and one of those 2 was a request for revision of a prior chamber judgment. It is unclear why the decline has taken place. One can only speculate that states have not considered that the use of chambers provides sufficient advantages as compared to the full court, or indeed as opposed to submission to arbitration. With regard to factors that the parties may consider relevant in deciding whether to submit a dispute to the court, the issue of composition of the bench is one where, though there is not complete discretion on the part of the court, the provisions dealing with ad hoc chambers still provide some flexibility to the court. Questions may be asked as to whether further flexibility in that regard is possible. For example, rather than establishing an ad hoc chamber of 5 judges, with at least 3 members of the chamber being members of the court, and then 2 ad hoc judges, might it be possible to have an ad hoc chamber of 3 judges, with only 1 judge being a member of the court and the other 2 being ad hoc judges? It seems to me that no provision of the statute or indeed of the rules prohibit this possibility, but that prospect has not been particularly well received in the literature. This is because the establishment of such a chamber, as I've just described, would entail that a judgment which is to be considered under the statute as that of the court was rendered by a bench containing only 1 member of the court. However, perhaps this ought not to be seen as a decisive consideration, since it is precisely the point of the statute that the court does not mean the full court or even a majority of the full court. The chamber for these purposes is the court. And it also seems to me that one's receptiveness to this idea depends very much on what one thinks is the goal of adjudication by the ICJ. Is it the settlement of the particular dispute, or is there something about the development of the law by the court? If one takes the view that the latter consideration is a primary consideration, then it might indeed be unattractive that only 1 member of the full court is involved in the decision. it may be thought that one possible advantage of arbitration over the court is the possibility of the parties to determine to some degree the speed of the proceedings. This may raise questions as to whether there is anything that the court may do to speed up the proceedings before the court. I think it is worth pointing out that though there are some cases before the court that have taken an exceedingly long time to complete, there are other cases that have been completed within a relatively short period of time. It appears that in cases where the parties seek to achieve a speedy conclusion of a case, the court is able to do so within its current procedures and practices. However, if it may be assumed that states on occasion desire some procedural flexibility with regard to particular cases, perhaps because of the nature of the case, the question arises as to how far this is possible under the court's statute. Perhaps there's the possibility of looking again at the rules relating to the Chamber of Summary Procedure, a chamber of the ICJ which has never been used, though it was used once at the time of the PCIJ, and perhaps providing the possibility that the parties might be able to adapt some of the procedures if they choose to refer cases to that chamber. Let me conclude this talk by simply thanking Judge Donohue for her brilliant lecture, for inviting us to think again about the goals of international adjudication, and inviting us to think about the particular ways in which we can work towards improving not only the working procedures of the ICJ, but thinking about the ICJ within the broader context of international adjudication.
Before I open up for questions, I was wondering if Judge Donohue would like to respond to some things that were raised by Professor Akande. You can do it seated or standing, whichever one you prefer.
Why don't we just take some questions and dive in and
dive into the questions. Okay.
Comments will flow.
All right. So we have microphones and the two rows. So if anybody's interested in asking a question, we would like them to come up to the microphone and start with questions. Sure. It would be good to introduce, of course, everybody knows you, but
Sean Murphy. I'm the president-elect of the Society. My thanks to both Judge Donohue and Professor Akande for wonderful remarks. One comment and one question. The comment is that I'm involved in a project at the International Law Commission on the drafting of what might be a new convention on the prevention and punishment of crimes against humanity. And draft Article 15 is a draft article that would call for interstate dispute settlement at the ICJ. So I'm hoping that Professor Akande will have an ability at some point in the future to say, actually, we do have a new treaty that calls for this. The comment is, or the question is, with respect to the chambers at the court, I'd be interested in Judge Donohue's reaction. There was, I think, a feeling at one time when I was involved in the formation of a chamber that one problem, even using existing judges on the court, and the problem becomes even more exacerbated if one moves in the direction of persons who are not judges, is the party's ability to control to a certain extent who those judges would be. It is formally a decision of the court, but when the two parties ask the court to form the chamber with particular judges, and so if you then select judges that are all from, say, a particular region, and yet then regard that as a judgment of the court, does it skew perhaps the way that we tend to want to think of the court's decisions as being a reflection of global views in some sense?
Thank you, Sean. You know, I must say, I get asked about chambers very often. And it's a complicated question. But if we look back to the period where the court changed its rules, that's when the Permanent Court of Arbitration, for example, was still in its Sleeping Beauty phase. Imagine the options memo that you'd be writing as a foreign ministry lawyer. What are choices for settling a particular dispute then? It would look pretty different from the way that it would look now. And so, whereas the chamber of the ICJ was seen as having some advantages as compared to the ICJ, the idea of arbitration supported by the PCA might not have gotten the same prominence in that options memo that it would get today. So there's an option for a smaller mechanism with more party control that is, one can easily see. I should say, assuming that one can find a basis for jurisdiction, either through ad hoc agreement or through some other hook. The thing that strikes me the most within the ICJ about the question of chambers is that parties don't ask for it. We can develop chambers, and I think within the current court, there would be openness to a certain degree of flexibility about how a chamber would be organized. But the thing that always strikes me is that when we think of the nickname World Court, there's a tension between the world part and the court part. So my hypothesis has always been that when a potential applicant is deciding, should I take this case to the ICJ, they probably do think about whether a chamber would be better. But there must be a belief for many applicants that the power of the result, because of course they hope to win, will be greater if the decision is rendered by the full court as opposed to a chamber. As a formal matter, the two are on equal footing. But the effect for states must be seen as something different, chamber versus full court.
Would you like to, Professor Caron?
So I agree with those points that have just been made. And it actually led me to think a little bit about the point that Judge Donohue made in her lecture about elections to the ICJ. I mean, what she says is obviously correct, that the primary emphasis must be on the quality of the individual candidates. But the fact that parties seem to want the authority of the full court suggests that there is something about that mix of nationalities which they regard as important, which then suggests that in the election process, even though, as you say, the emphasis must be on the quality of the individual candidate, there is something still significant about having that diversity of nationalities for strengthening the authority of the decisions which comes. And, you know, hopefully it's not a trade-off. Hopefully those two things should complement each other.
Very good. I think we have another. Yes.
Yes. Good evening. Anna Spain-Bradley, University of Colorado Law School. Thank you, Judge Donohue, for your wonderful remarks tonight. I would like to ask a question that goes to your important remark about the potential increasing politicalization of electing an ICJ judge in both the Security Council and the UN General Assembly. And to that effect, A, do you think it's gotten worse? And B, what do you think the potential causes for that? I think there has been some idea that perhaps the Security Council's own internal frustration about the lack of representation on the council, that in light of changing politics and changing power dynamics in the world, the UN General Assembly's own internal frustration with the Security Council, that somehow maybe this might be showing up in the election process, or do you see it a different way? Thank you.
That's a hard question to answer. I don't know the answer. I don't know whether it's changed over time. Probably it has. Certainly, the frustrations about the lack of change in the composition of the Security Council, which for a while seemed like it was something that we might see, has to contribute to the problem, at least in respect of resistance to the idea that the states that have permanent seats on the Security Council should also have judges of their own nationality on the court. And we'll see how that plays out in the future. I just don't know. But the thing that strikes me is that vote trading is both understandable and pernicious. And at least in my experience, the United States doesn't engage in vote trading, which I think is probably a little bit easier for a candidate, but it seems to govern the way New York operates. And so what that means for me as an ICJ judge is that when a state is prepared to trade its vote for the ICJ, for a vote on some other matter, some other election, it means that that state considers the other election to be more important to it than the ICJ election. And it's entitled to think that, but the reflection is important there. What are the other factors that are more important, and how can we collectively make election to the ICJ move up in the priority list of various states so that people are trading in order to get their candidates elected and not the other way around?
Any other comments, questions from the audience? I don't see any other hands. So I'm going to venture and ask you a question. The WTO appellate body is in danger of becoming obsolete. I mean, not obsolete, but stuck once it comes down to 2 appellate body members. I know we are going to be discussing this on Saturday morning. But so criticism has been that they have engaged in too much gap filling and lawmaking beyond. That's the US criticism. I wonder if you have any thoughts as to whether they have actually done that, or there's something, legitimacy issue that should have thought. And I don't want to personalize it, but just your thoughts on this, because those of us in the trade area are very preoccupied with this. If you don't want to talk about it, that's fine too.
Well, I won't answer specifically on the WTO.
Yeah.
I certainly haven't taken the time to study the outputs of the WTO closely enough to have a view on that. But I will say that in every decision that we render, one of the hardest questions for us on point after point in that decision is, should we write broadly or narrowly on a particular question? We usually have choices. We usually have ways to address a question purely on the facts, leaving aside difficult legal questions. We can address the question on a broad proposition of law or on a narrow one. We talk about it within the court. We come to a view that's reflected in our judgment. You sometimes see different perspectives on that in separate opinions, but it's always hard. It's always hard to know what the right thing is to do. And in every judgment that we render, there's a pretty good chance that somebody will write a comment that says, the court missed an opportunity to develop the law on X. And somebody else will say, once again, the ICJ strayed from its mission and engaged in lawmaking.
Right.
So the main thing I will say in defense of the WTO is it's harder than it looks.
It's harder than it looks. Would you like to say anything? No? Well, on behalf of American University Washington College of Law, American Society of International Law, thank you for being here. Thank you, Judge Donohue. Thank you, Professor Akande. I invite you all to join us for the reception. Thank you again.